appellants, and I would like to reserve 7 minutes for rebuttal.
We only allow up to 5.
Up to 5? Okay.
So you want 5 minutes?
That'd be fine.
Okay.
The ultimate question in this case is whether the proof established by clear and convincing evidence at least one ground to terminate parental rights of the father. It did. And the first and most clearly proven ground was the father's failure to establish paternity. There are 3 elements to that ground. 1, the respondent is a putative father. 2, he received notice of the alleged paternity. And 3, he did not file a petition to establish paternity within 30 days of receiving notice. In this case, we know that Mr. Levin was present at Isaiah's birth, but according to his own testimony, it was in June of 2019 when the child's mother told him that he might be Isaiah's father. And in his answer to my client's petition, he admits that he was a putative father at the time they filed their petition. But he didn't file a petition to establish paternity until 17 months later, in February of 2021, which was after the department had filed its termination petition. So those 3 elements that are necessary to the ground are there. Now, the trial court, in its final order dismissing the ground, said it did so because the father's failure to seek paternity simply wasn't willful, were the words of the court. But that was the wrong standard, because the case law, as I cite in page 21 of my brief, willfulness is not required for this ground. Whatever else father may have done, according to his own testimony, he didn't file a petition to establish paternity within 30 days of learning that he might be the father. Now, in its brief, the Attorney General, on behalf of the department, says that their client, the department, messed things up so badly that you shouldn't hold it against the father for taking so long to file a petition. I don't find any basis in law for that. There are 3 elements. They were met because he did, according to his testimony, he did a lot of things, but he didn't do the one thing he needed to do, which bleeds over into some other matters on this case. He also failed, or his parental rights could also be terminated under G14. And it's important to remember that when you look at that ground, you look at the time the petition was filed, not at the time of the trial. So the department filed first. They filed their petition in January of 2021. The appellant's petition, my client's petition, was filed about 2 weeks later, and the father filed his petition to establish paternity between those 2 dates. From June 2019, when Mr. Levin learned that he might be Isaiah's father, until November 2020, when he presented himself to the court that he knew was overseeing Isaiah's case, his actions and inactions demonstrate a lack of willingness to assume custody, and here's why. During all that time, he knew that Isaiah was in foster care. He knew there were regular court proceedings. He had regular contact with Isaiah's mother, but he didn't go to court until November of 2020. And when he did go, or what he did do, according to his own testimony, were these things. He made one personal visit to the department. He had a few phone calls with a DCS employee. He sent emails to other agencies that could not have assisted him in filing a parentage petition. He spoke to the mother about a plan to obtain DNA another way other than going to court, and he tried to contact the mother's attorney to see if he could get some assistance there. But again, what he didn't do was the one thing he could have done, and he knew where the court was. He had access to the court. He simply didn't file a petition to establish paternity. This establishes a lack of willingness, which is the first prong under 14. The second prong, there were two experts and only two that testified in this case. One for,
I mean, he didn't file the petition to establish paternity, but he did do other steps. I mean, he approached DCS. I mean, doesn't that show willingness?
oh, going to the willingness ground.
Yeah. I mean, it seems like to me the first prong, I just don't see clear and convincing evidence, the first prong here.
Right, because it is the appellant's burden to show his failure to do it.
But let's talk a little bit more about G9, though.
Okay.
Is it clear here, you say there was an admission that father was putative father
Yes.
at the time, but is it clear that he was, in fact, a putative father? I mean, I have to say, the statutory definition of putative father is very difficult in cases like this, especially where you have someone else on the birth certificate, correct?
Yes, and she was married to someone else.
And she was married to someone else. And mother doesn't think this father was in fact the father. So how does the father here actually fall within the putative father definition under the statute?
As of,
Under the statutory definition.
aside from his admission,
Right.
when she told him that he might be the father.
So that's enough, that the mother says, you may be, so that makes you a putative father.
Credible statements.
Okay.
The, see, how am I doing? A related issue that I raised was the concern about the credibility findings, that it was unfortunate that the judge who heard the proof and saw the witnesses and all of that retired, I think, a month after. I think he retired in August. The case was in July, and he retired without entering an order. So a couple of months later, the presiding judge provided. Anyway, the chancellor who issued the opinion had the same things that you and I had to work with, which is what you've called the cold record. I didn't represent the appellants at the appeal, so I'm working with the same record that the court is. And I do understand.
I mean, it sounds like that counselor should have said, well, we want to submit or have live testimony, right? I mean,
And I acknowledge there's nothing in the record that indicates that appellants, that my predecessor, there's nothing in the record that says he said you need to do this. It just seems to me that, and I understand the judge could have done it, and I understand there's ways of gauging credibility other than by eyeballing the witness. But in these cases, we're usually here talking about other ways in which the due process, the heightened standards of proof on terminations and all that. It just seems like where so much is at weight, so much depends on the credibility determination that the court made, obviously giving great weight to the uncorroborated testimony of Mr. Levan. It's surprising that he didn't want to, but I have looked, and I find nothing in the record where that a request for additional testimony was made. Also, I see I have a few seconds. Also before you today.
yeah, but and I know you're trying to get another point,
That's good.
but and pardon me, but I want to focus again because I'm really struggling with the father was a putative father at the time of the petition. Can you point to me which of the 36(1)(117)C elements this father met?
know that I can. I don't have
Okay,
the statute with me.
That's
I'm
fine.
sorry.
I've got it, but I can look at it.
Okay.
Okay,
All
so
right.
I'm sorry.
Do you want me to supplement with anything? I just don't.
You know, that might be helpful for me, yes.
Thank you.
So maybe if we could get within 10 days.
Can I do
after-
that by supplemental brief or letter or? what?
We'll enter an order.
Thank you.
Yeah.
I'm out of time. All right, thank you.
Good morning, may it please the court, Catherine Adams for the Tennessee Department of Children's Services. Mr. Stewart and I were going to split the appellee's time, with me taking the first 5 minutes on behalf of the department and him taking the rest of the 10, if that's amenable to the court.
That is amenable to the court, so you will have 5 minutes and he will have 10.
Yes, thank you, Your Honor.
Okay?
So, counsel, can you start by addressing the G9 ground here?
Yes, Your Honor. So, under 36.1.117C, is the department's position that he would meet C2 in that when the department filed their petition to terminate at the end of January, father had filed a pro se petition in Davidson County stating that, like, holding himself out to be the father. He had filed a petition for custody in which he stated he was the father. So then, by that definition, he would be a putative father at the time of the filing.
Okay.
But he didn't, it would be our position that he did not obtain that putative father status until that filing, which would have been after the DNA test that he received back earlier that month. So as stated by the appellants, this is a termination of parental rights proceeding in which both foster parents and DCS filed separate petitions to terminate father's rights. Those petitions were tried together and both were dismissed by the trial court. Foster parents appealed that dismissal and DCS did not. On appeal, DCS agrees with the trial court that neither party established a ground for termination by clear and convincing evidence. Just briefly on the credibility determination argument, foster parents waived any right to seek a retrial on this issue by failing to request the recall of any witnesses at the final hearing when given the opportunity. I recognize that counsel changed, but the record does not reflect that there was any request by any party to recall a witness at the final hearing held by Chancellor Dean. Regardless, there's nothing improper about the court making credibility determinations based on a cold record. While DCS acknowledges that the deference this court affords those credibility determinations is different since it wasn't live testimony, those determinations aren't invalid just in themselves. Turning into the grounds, and beginning with the ground of failure to establish paternity. Appellants are correct that the trial court found that in June 2019, mother informed father that he might be Isaiah's father and that father filed a formal petition to establish paternity February 1st, 2021. However, the trial court also made lengthy findings as to the circumstances in this case. The trial court found that from the moment father discovered he might be the father, he made numerous efforts to determine whether he was the father, made it clear from the beginning that if he were, he wanted to assume legal and physical custody of Isaiah. Further, the court found that father made and took every reasonable effort under the circumstances to attempt to establish paternity. The evidence in the record does not preponderate against this finding.
So have we ever, in analyzing G9, excused a late filing under similar type circumstances? I mean, it seems like to me the statute's fairly clear. You either file it within 30 days or you do not.
The statute is very clear and limited, and I was unable to find a specific case instance where this court held differently. However, with the findings by the trial court in this case that really amount to a detrimental reliance of the father on a DCS employee.
So it sounds like you're advocating, DCS is advocating for the position that there is a detrimental reliance exception to the statute.
Or that there should be in this case under these circumstances.
Okay.
Yes, Your Honor. And counsel for the appellants made the argument that the testimony was uncorroborated of the father, but it was also unrefuted. So the unrefuted testimony in the record is that father relied on statements by that DCS employee. And there is no willfulness requirement in the statute, and DCS acknowledges this, and DCS is not statutorily required to assist a parent. However, in this case, that detrimental reliance and principles of fairness really, the department advocates that the trial court did not err by finding that this ground was not established at trial. Moving very quickly to the second ground, failure to manifest an ability and willingness to assume care and custody. The appellants essentially reiterate their argument surrounding father's failure to timely file to establish paternity. This is not the standard for this ground, however. For this ground, courts look to the parent's lifestyle and circumstances and whether the parent has demonstrated willingness by attempting to overcome obstacles that prevent that child or the child from being in their custody. As stated, father had made clear to DCS that if he were the father he wanted to parent. There was other testimony in the record that he did manifest an ability and willingness to care for Isaiah. And as such, ultimately DCS on appeal argues the trial court properly determined that no grounds to terminate father's rights were established by clear and convincing evidence. And for that reason, the judgment of the trial court should be affirmed. Unless there are any more questions, I'll yield my time.
Seeing none, thank you.
Clerk for Sam Lewis here 35 years ago. And it's remarkable to me the sameness of this room. 35 years later, it's the exact same thing it was when I first used it.
Just a little brighter. the
Yeah, a
lights.
little brighter, and they record things now. Besides that, it's pretty much the same. One of the things Judge Lewis taught me is that despite years of litigation and a lot of time spent, the first thing you should try to do is put in a few sentences what the case is about and then talk about it. And that's what I'm gonna do to start off with. This is a case where a man found out he might be a father. He fought to determine if he were a father and then to parent his son. And the Fosters now want to take away his constitutional rights to be a parent to his child and father his son because he did what DCS told him to do. That's what this case is about. If you look at the facts here, he had a casual relationship with this woman who lived with somebody else and was married to a third guy, met downtown periodically, and she got pregnant and he knew it. But she told him, there's no way you're the dad. The time doesn't match up. The man she was living with believed he was the dad. My guy believed he was the dad. Mr. Levin did.
But there was a point where mother did believe he was the dad.
She did. So what happened was after the child was born, all right, mother's Caucasian, living boyfriend is African American, child's pigment is light when born, but you don't know. 4 months later, mother's in jail. They bring a picture of the baby to the mom, and she sees a Caucasian baby. So that's the first time, 4 months after the baby's born, which by the way is my wife's birthday, February 5th, so I can actually remember it. February 5th, 4 months later, she sends an email to Mr. Levin and says, you may be the father, not you are. And what does he do? You know, we have all these problems with DCS and children in hallways and other places. I wish the state of Tennessee had 100,000 more Jay Levins. He's got a mom he's barely got a relationship with, a child born on drugs who's autistic, and what's the first thing he does? He goes straight down to DCS and says, if this is my child, I want to parent him. Here's my name, here's my address, here's where I live, here's my work, and here's my social security number. What do I do to find that out? And DCS tells him. And by the way, at this time, DCS is under a court order requiring it to unite a parent and child. If DCS had simply done its job when he went down there, none of this would have happened. He'd have had a DNA test, as he asked for and was ready, willing, and able to do, and this would all stop dead in the spot. But it didn't. And what he did is did what a government official at DCS told him to do, which is wait. We've got your information, and we're investigating this right now, and you have to wait on us. So he did. He got frustrated while he was waiting. He made phone calls. He called the lawyer of the woman who's in jail. He arranged a time to meet with her when she was supposed to get out of jail to run his own DNA test. He was so desperate. It's all in the facts section of the brief. I won't go into all of it. He sent emails. He did everything. This guy was beating his head against the wall. Now, as the trial judge found, he was naive and not sophisticated, all right? But he was trying. He wanted to know if he was the father, and then if so, to parent his child. Then COVID hits, and contrary to what was stated here, he didn't know about any court appearances. The record is clear. He had no idea of any court appearances. Mother told him there were none. They had meetings periodically. He didn't know what those were. But the second when COVID shut it down, he sent an email to the juvenile court in which he said, I want to know if this is my child, and if so to parent my son, what do I do? He sent an email to DHS, who he believed to be the father company of DCS. What can I do? What can I do? What can I do? He called the mother's attorney. He said, hey, can you help me out? And the mother's attorney's telling yes. He's waiting. He's jumping from foot to foot to foot. Am I the dad? And if so, I want to parent my child. That's what happened. And finally, the first post-COVID court hearing that actually happens in person, he's able to show up. He shows up and says, I think I could be the dad. I still don't know. I've been waiting on DCS for a year and a half. Can I find out? Judge says, oh my gosh, yeah. Orders a test in December, comes back in January. January, the day the test comes back, he gets it, and I asked him, what's the first thing you did on the stand? I thought I was going to get a legal answer. Called my family and said, I'm going to be a dad. That's what he did. First day. And then he walked down and filed a petition to say, I want to be father. He's getting nothing but pushback from DCS. I was shocked by this. Nothing but pushback from the fosters. I was shocked by this. So he files his petition, and then he hires me.
What is your position on my concern about the putative father situation and when your client became the putative father?
He became a putative father. I think the state is right. He became putative father when he said, I think I might be the dad. January, the day he got the DNA test and walked down there and said it, and then they filed, but it just, all that does is add a willingness.
Tell me what date you think that is, the record
I
shows.
think, Judge, I don't remember exact dates, there's so many here, I think it's January 14 of 2019, but I'm not sure. But all that does is add a willingness burden to him, and it makes that statute applicable. And the one thing that was not said is the statute, while it says within 30 days, it doesn't say you shall keep somebody from being a dad if they don't do it within 30 days. It says the court may.
That's why you have this best interest analysis that comes next, which we never got to in this case.
But actually, Your Honor, I would respectfully disagree. And I've read case after case, and I was very ignorant on these, okay? I took this at a reduced rate. I've been helping the family. I'm not super knowledgeable about this stuff to start off with, but I've learned a lot. I've read every TAM for the last 3 years on these in-ray cases. And what my understanding is they look to the conduct of the parent. It's not simply whether you did this within 30 days, and you will see 12-page, 15-page, 20-page, 40-page opinions that start off with the parent is a drug-addicted, bad person who's been in jail and robbed people, and we still aren't sure whether we take away his parent rights. So it's a may thing, and all it does is simply establish that the court may consider that, but simply because within 30 days of the fact he may be the father, he didn't file something, that is not the standard in the state of Tennessee, I do not believe, and I don't believe it should be, to take away a father's rights. It simply, what it does, it gives the judge discretion. And that's what the judge is supposed to do. They look at these cases, they evaluate the case. That's why we have a guardian ad litem, who, by the way, joined the father after carefully seeing him. That's why we have child and family services appointed in this case. A lady who he spent, by her own testimony, hundreds of hours trying to learn about his son, learn about autism, become a good father. He's done all of those things. And that's exactly what the trial court saw when it read the transcript twice and then had the in-person meeting. And I give Your Honors, there's a case in there about deference and credibility. There's actually a case where there's just a telephone call and that's sufficient to give deference to the trial court. Just a telephone call, not even seeing him in person. We had an in-person meeting, no live testimony, but he saw the witnesses and observed it, and I think there should be some deference. But even if you don't and say, nope, no deference at all, I don't think it matters one bit because the record supports it. Trial courts give credibility findings all the time in cases. For example, a doctor's deposition. They read it. I find this credible. I find this not credible. All that does is on appeal, this court can reverse the trial court without giving them deference. But if you look to the actual facts in this case, every witness who has seen or witnessed Jay Levin spend any meaningful time with his son has testified they're bonded, he's a loving father, they are connected, and you should not sever this bond. You heard the statement about Allison Peake, the expert witness for the other side. She never even met Jay Levin. She never met Isaiah. She doesn't know anything except what she read. Dr. Jay Woodman was hired. He is an expert. He met with them. He evaluated them. He spoke with the guardian ad litem. He spoke with the Child and Family Services expert brought into the case by DCS, who sided with father and said he should be the proper guardian for this child. So all the testimony from every witness is that this is a good, loving father who wants to bond with his child. This is a travesty of a case that it took this long. DCS should have immediately done the DCS testing when he got in there. And as the court found, yes, he was naive. Yes, he was not sophisticated. No, he didn't know that he had to go beyond talking to DCS and doing what DCS told him. Yes, he relied on them. But to say because he didn't file a piece of paper within 30 days when he's doing all these other things, that's why I think the court has discretion. That's why it says you may terminate a father's rights, not you shall. And I pulled these cases that the foster family relies upon. Every single one of them. Mother gives up her rights because she's drug addicted. Father's in jail. Father's a thief, a felon, doesn't want his child, or only wants to not give up his rights as a child so he can get out of jail for compassionate relief, or is in the business of fathering children but not supporting them, has never supported, has 8 kids, 5 kids, 12 kids, and doesn't do anything. This is a man who says, I was in the middle of my life, I hadn't found a person I loved yet, I had a romance, I immediately stepped up, I immediately wanted my child. He spent all this time, all this money, and all this effort to unite with a child he loves. And just think about this for a minute, too. Realize this order went down in April of last year. This case was sent back to the trial court. The Fosters have fought him since day one. They filed a petition, a verified petition with all kinds of inaccurate things and assertions about him being a bad parent or unsafe, all of which turned out to be false and all of which they dropped at trial because they had no support for it at all. All right, on appeal, the second this case gets appealed, it could have been dropped. It could have been left alone, one side gets it. They didn't, not only that, they doubled down. They filed a motion with the court, with this court, saying we want to stop the unification process that the trial court has ordered. I see I'm about to run out of time, and so Your Honor's overturned it. We have had 1 year now, almost, and it will be more than that by the time this court issues an opinion, during which this case has been sent back and there's been a carefully crafted process of uniting a father and child. If this court issues an order reversing the trial court, you will rip apart a 1-year process of a loving father and a child being united. That's the truth. Thank you.
Thank you.
If I may, to answer your question,
Well, I think the concessions on the other side sort of resolve the need for briefing because both DCS and father seem to acknowledge he was a punitive father.
Okay.
So
okay, that's good. Because if there's going to be additional briefing, I wanted to be able to address the thing I heard for the first time today about detrimental reliance.
okay.
All right. Also before you today is a motion that I had filed to strike part of the father's brief, or the joint brief of him and the guardian ad litem, and the court entered an order saying it was just, he replied and put it today too. I think that's significant because not that it's dispositive of whether they prove grounds or not, but because we have rules and we should go by them. We have a record. We're supposed to argue from the record. We're supposed to write briefs about the record, not talk about things that happened months later. And I'm asking you in that motion to strike, I think it's 2 paragraphs that occurred after the judgment was entered, occurred in another court in another county. I wanted to make sure I didn't waive any issues. That I addressed in the briefs the father's request that you dismiss this appeal because it wasn't resolved within 6 months. And that's, the reply to that is simply that at the time of the delay, the statute provided a remedy that neither he nor the guardian ad litem took advantage of. They didn't file a motion with this court to expedite the appeal. Regarding attorney's fees, his request for attorney's fees at trial is waived because he didn't raise the issue there. And he asked for attorney's fees on appeal, citing TCA 365103C. The case that I cited, In Re MLD, I believe clearly states that attorney's fees are not recoverable in termination cases under that statute because In Re MLD was a termination case. So I just don't think there's any way to do that. Mr. Scott and I would agree on one thing, and that is that this was an unnecessarily difficult case, compounded by COVID, I suppose, the scheduling and all of that. But you're asked, I submit that the proof is clear that the ground of failing to establish paternity has been established. It was pled under G9, which by case law and by statute are, quote, easier to prove than the others anyway, for the reason that it's a putative father. But that aside, it's if you acknowledge that he's a putative father and that he received knowledge of that he might be of the alleged paternity in June of 2019. One thing I did want to point out, he actually filed 2 paternity actions. The first one was in Davidson County on February 2nd, 2021, which was about a week after the department filed its termination petition in Davidson County. When my clients filed their termination petition on February the 8th of 2021, they filed in Robertson County. And then in April of 2021, he filed another parentage petition in Robertson County. So the first, if you look at that, the first time he filed a parentage petition was between the 2 filings of the termination petitions. Anyway, this idea that he should be excused on some, equitable theory from complying with the statute, and that my client should be denied that they proved the ground to terminate his parental rights, just should not be well taken. We are, for good or bad, the trial court, having dismissed the grounds, did not engage in a best interest analysis. I would love to talk about best interest, but that's not before the court for any of us. And that's where we would get to if it goes back.
Thank you. Thanks to all 3 of you. I believe that concludes the morning docket. So would you recuse us, please?